Bad news, everyone. A federal court has just upheld Massachusetts' notorious handgun roster law, and I've got to tell you, it is exactly as outrageous as it sounds. When I first saw this ruling, I couldn't believe it. This is the kind of decision that makes you shake your head and wonder what on earth is happening to the right to keep and bear arms in this country. Once again, a so-called safety regulation is being used as nothing more than a tool of control, and if we don't pay attention, the consequences are going to spread far beyond Massachusetts. The case at the center of all this is Granata versus Campbell. I've been following it closely for months because I knew how high the stakes were. The plaintiffs included two licensed gun owners in Massachusetts, a local shop called Gun Runner, and the Firearms Policy Coalition. Together, they went up against Attorney General Andrea Campbell and the Secretary of Public Safety. Their argument was simple and powerful. This handgun roster is not about safety. It's a backdoor ban, and it strips citizens of their Second Amendment rights. Here's how it works. In Massachusetts, you can't buy a handgun from a dealer unless that exact model is listed on the state's approved roster. To get on the list, a gun has to pass a series of state-mandated tests. A drop test's melting point requirements, tensile strength, so-called child-proofing features like heavy 10-pound triggers, and mechanical add-ons like loaded chamber indicators and magazine disconnects. If a firearm doesn't pass all of these, it never gets approved. What does that mean in practice? It means that many of the most common trusted handguns in the country are unavailable in Massachusetts gun stores. Glocks, like the 19 Gen 5 Sigs CZs Walthers guns carried by millions of Americans every single day, are blocked from sale. You can still get them through private transfers, but you can't just walk into a shop and buy one. I don't know about you, but when the government tells you we'll decide what you're allowed to own, that sure sounds like a ban to me. And let's be honest with each other. If this were really about safety, we'd see clear uniform standards applied across the nation. That's not what's happening here. Instead, Massachusetts has built a bureaucratic wall designed to keep new models out of the market. Glock Gen 5 pistols are used by law enforcement from coast to coast because of their proven reliability. Yet, ordinary citizens in Massachusetts are told, no, you can't have that. Does anyone actually believe that's about protecting kids? I don't. This is about control. The plaintiffs hit this point hard, pointing back to the Supreme Court's Bruin decision in 2022. That case set the standard. Any modern restriction has to fit within the nation's historical tradition of firearm regulation. And let's be real, there's no tradition of banning common popular handguns just because they don't have a chamber indicator or a certain melting point. The Bruin test makes that clear. By cutting off access to widely used handguns, Massachusetts isn't regulating safety, it's prohibiting freedom. That's why this case matters so much. It isn't just about a list on a website. It's about the government exercising raw power to decide which rights you actually get to use. Massachusetts has a long history of pushing restrictive gun laws, but the roster takes things even further. It turns the free market into a government-controlled menu, and if your gun of choice isn't on that menu, too bad. And here's the kicker. While the state insists the roster is for safety, residents can still buy these very same handguns through private transfers. If the guns are too dangerous for licensed dealers, why allow them privately? The answer is obvious, because safety was never the point. The real goal is to choke off supply, discourage ownership, and wear people down until exercising a right feels like jumping through hoops. This is the battlefield of Granata versus Campbell. And before we even get to the court's ruling, the roster itself already shows how far states are willing to go to undermine the Second Amendment. They won't call it a ban, but we all know exactly what it is. And if it stands, we should expect anti-gun states across the country to follow the same playbook. On August 29, 2025, the ruling finally came down, and it felt like a punch in the gut. The court sided with Massachusetts, upholding the handgun roster and declaring it constitutional. Judge Denise Casper made it official. In her view, the roster is not a ban, it's just a condition on the commercial sale of firearms. That little phrase carries massive weight because it gives the state cover to keep deciding what guns we're allowed to buy. The judge leaned on the Bruin framework to get there. Step 1 looked at the plain text of the Second Amendment. She admitted the right protects possession, but she claimed it doesn't guarantee the commercial sale of every type of firearm. And because the plaintiffs already owned multiple handguns, one even had 14, she said their right to self-defense wasn't really being burdened. I've got to be honest, that reasoning infuriates me. Since when does the Constitution say you only get your rights until you've collected a certain number of guns? Rights don't work that way. Step 2 was the historical tradition analysis. This is where things really stretched credibility. The state pointed to 19th century safety inspection laws, colonial gunpowder storage rules, bans on trap guns, and restrictions on giving pistols to minors. Judge Casper bought the argument, saying these showed a tradition of safety regulations and the roster fits right in. But come on, comparing trap gun bans to blocking Glock pistols in 2025. That's not tradition, that's cherry-picking history to justify modern control. The takeaway from her ruling was clear. Massachusetts can keep its roster because it's not seen as a ban-just regulation. She even leaned on language from the Supreme Court's Heller decision, which suggested some conditions on commercial sales could be lawful. That line has become a shield for restrictive states, and this judge used it to keep the roster alive. The Firearms Policy Coalition wasted no time firing back. Their statement was blunt: this decision is flat out wrong under Bruin. They said Massachusetts isn't regulating safety, it's denying access to constitutionally protected arms. By blocking dealers from selling hundreds of common handguns, the state is deciding for its citizens which rights they can exercise. That is the definition of a backdoor ban. And I agree with them 100%. What worries me most is what comes next. Because if this ruling stands, it won't just stay in Massachusetts. Other states like California, New Jersey, and New York are watching closely. California already has a roster just as bad, and they'd love the legal backup. New Jersey and New York could jump on board tomorrow. Imagine 50 different rosters, 50 different lists of what the government approves for you to own. That's not freedom, that's tyranny by paperwork. This is why the FPC has vowed to appeal. They're taking it to the First Circuit, and if they have to, straight to the Supreme Court. And they should, because this fight isn't about one state. It's about whether the government can micromanage a constitutional right until it barely exists in practice. We as gun owners can't afford to shrug this off. If Massachusetts gets away with this, your state could be next. The message is clear. The roster is not safety, it's control. And this decision is not the end of the story. It's the beginning of the next round in the battle for the Second Amendment. If we stop and think about the bigger picture, this ruling sets a dangerous precedent. Because if Massachusetts can get away with restricting access to common handguns through a so-called roster, what's stopping every other anti-gun state from doing the exact same thing? We've already seen California run with its own roster system, cutting off hundreds of models from their citizens. If this Massachusetts ruling stands, California's program gains even more legal cover, and you can bet states like New Jersey, New York, and Illinois will be lining up to copy it. Once the courts bless one roster, the floodgates are open. That means millions of Americans could wake up one day to find their gun choices shrinking year after year until the only handguns left are whatever the government approves. This isn't speculation. It's the natural result of letting bureaucrats decide what qualifies as safe. And let's be honest, they aren't motivated by safety, they're motivated by control. If they can whittle down the market to a handful of models with government-approved features, then they can effectively control who owns what. That's not regulation. That's prohibition through the back door, and it's happening right in front of us. But let's flip the scenario. If the Firearms Policy Coalition succeeds on appeal, the impact could be massive in the other direction. Imagine the First Circuit, or even the Supreme Court, striking down the roster ruling that states cannot arbitrarily block access to handguns that are in common use. That would not just nuke Massachusetts' system, it could wipe out California's as well. Suddenly, hundreds of models that were blacklisted would be back on the shelves. For once, the courts would actually be expanding rights instead of narrowing them. That's why this case matters so much. It's not about one shop, one plaintiff, or even one state. It's about whether the courts will draw a line and say, you can't play games with a constitutional right. Because if we let states decide what we can or cannot buy, then the Second Amendment becomes meaningless. And if they can do it with guns, they can do it with any right. This is the test, and it's happening right now. The roster also creates a burden that hits ordinary people the hardest. Wealthier gun owners might still find ways to track down off-roster guns through private sales, but the average citizen gets boxed out. Dealers can't stock them, shops can't advertise them, and buyers are left navigating loopholes. That's not just unfair, it's intentional. The goal is to make exercising your right so complicated and so discouraging that fewer people bother. And once fewer people bother, the state gets exactly what it wanted: a disarmed, compliant population. I know some folks like to say, well, at least you can still own those guns through private sales. But let's be clear, that's no consolation. Rights don't survive by forcing people into back channels. Rights survive by being openly available, respected, and protected under the law. If you need to rely on secondhand deals to get a Glock or a Sig that most of the country can buy at a store, that right has already been gutted. We as gun owners can't look at this case as somebody else's problem. This isn't just about Massachusetts. This is about every one of us, because if it stands there, it will spread. If they can do it to our brothers and sisters in New England, they can do it anywhere. That's why FPC's fight matters, and that's why you need to care about what happens next. I'll say this plainly: the roster is a ban in disguise. The court may pretend it's a harmless condition on commercial sales, but we all know better. And if we don't push back, if we don't support the fight, this model will become the template for every anti-gun state in the country. The fight is far from over. The appeal is coming, and if necessary, this case will go all the way to the Supreme Court. We can't sit on the sidelines. We have to stay alert, stay vocal, and stand together. Because at the end of the day, if Massachusetts can decide what guns its citizens are allowed to buy, your state could be next. And that's not something any of us can afford to ignore. https parenti.asis xlvha2rec wamofbshpks parenti.asis obg2zbut